role. Be prepared for an appeal. Understand the importance of the record. Because if you do everything right, you dot your I's and cross your T's, the court of common pleas is confined to the record that you've created. They can't take any additional testimony. Okay, so that's why the record's important. You know, obviously, I think in the highly contested or controversial cases, you need to have a sense of formality. You should all have a podium. Highly recommend a court reporter. The true cost of a court reporter is really if you have to order the transcript. That's where it's kind of like, that's where it gets expensive. But here's the thing, if you have somebody who appeals your decision, you should be requesting the court to tax the cost of the record preparation to the losing party. The statute allows for that. So if I, you know, Concord Township denies me my variance, I don't like it, I appeal it, they order the transcript and it costs $500 or $600. We go to court, everything's done right, they file the motion to tax the cost, Pete Griggs loses, I have to pay the cost of that record preparation. I've also used it as leverage to settle cases. I've had a few cases that the record preparation has been between $2,500 and $4,000. And I've used that as leverage to settle a case, settle cases before. But always have a court reporter there on the controversy. There's no reason not to, guys. I mean, tell your trustees not to be cheap. Administering oath, we've already talked about that. Individual versus mass swearing in, just get confirmation. Limiting testimony. Again, that goes to the people that have standing have an absolute right to testify. The people that don't have standing don't have an absolute right. The problem is how you go about determining that. So as a general rule of thumb, I just kind of let everybody testify. And the good chair people know how to control me. You know, if you get the guy that shows up to every BZA meeting, you know, and just argues about everything, then you try to move them along the best you can. You know, let's say you have a group of residents that are all getting up and say the same thing. Well, after the third one, you say, "All right, folks, I'm going to call the next person, but we've already heard a tremendous amount of testimony on how this is going to reduce property values and increase crime." Going to be, you know, create sound pollution or light pollution. If there's anybody that has anything different to say, please feel free to come up. I mean, so, you know, you kind of get used to kind of controlling the room a little bit. But again, that's the hard part. So I always just general thumb, let everybody talk. Cross-examination. 2506 allows for cross-examination. Has anybody had that happen yet in one of your BZA? I have. It's interesting. And the question I often get is, what if there is no attorneys involved? Typically, I see it when there's attorneys. But what if it's just two neighbors that absolutely hate each other? Does the neighbor have the ability to cross-examine the applicant? I think they do. I think they do. And this is where I would really try to figure out standing though. But if I had the one guy that shows up to everything, and he doesn't, he's halfway across the township, I would probably not let him cross-examine anybody. Right? So try to figure out where he lives. Is he contiguous or adjacent? And then maybe say, you testified already. It appears you don't have standing. We're not going to let you cross-examine the applicant.
Once you establish standing, can you still maintain them to relevance?
Say that again.
relevance. In other words, they're just bickering over some guy let his dog out. It has nothing to do with the requests that you're hearing.
Yeah, so, I mean, obviously you want relevant testimony, but that's a good point. And I think someone came up and asked me this question as well, is to how you weigh evidence. And do you give a little more weight to contiguous or joining property owners? The answer is I don't know how you can. Right? Not, from a legal perspective or from just being a human being, for heaven's sakes. I mean, they're the ones that are directly impacted. So obviously, how you weigh that testimony compared to somebody who doesn't have standing, who's a mile down the road, should be different. But it's not the end all be all. I want to be perfectly clear. What I'm not saying is just because a bunch of people show up that you deny somebody's application, right? You got to have tough skin, BCA. You got to have tough skin. And sometimes you have to make unpopular decisions. Having 10 next door neighbors show up and bitch about an application is not a reason to deny. Okay?
One other question around timing. We generally don't establish like a time limit for testimony. How do you control if you don't have a standing rule that says X amount of time and something goes haywire and people are
right, so,
going on and on?
And I agree. You're doing it the way I would tell you to do it. I wouldn't have a time limit. But if you get the guy, and again, this goes back to standing and knowing, trying to figure out who has it, who doesn't, which can be complicated. But I think worst case scenario, if you just have some guy, I've been in BZA where the guy has literally started reading the Constitution.
Yeah.
And I think that under that scenario, a court's going to say you acted reasonable. I think you could direct him to the merits of the application. I think you can also, at some point in time, start questioning him about where he lives and ask him if he has standing and then shut him down. Or even, if he does have standing, he's just rambling. I think you can direct him to the relevancy of the application, and then if he doesn't comply, then you roll him out of order and tell him to sit down. If he doesn't do that, and he starts throwing papers everywhere, you call sheriff. Have arrested for unlawful disturbance of a public meeting.
The reason I ask is the appeal issue. Because if you're talking about the issues for appeal, and that would be like you cut somebody off, does that mean you're not here?
That is one of the reasons listed in 2506, where if somebody could supplement the record, if I wasn't allowed to present, I'll testify. But again, you just have to, use common sense really on that issue. But I think if somebody's being completely unreasonable, a court's going to decide if you want. We have a sample hearing format in there. It is what it is. Exhibits. Make sure that when you're getting exhibits in, you're labeling them, numbering them, and that they're made part of your record. Okay? Make sure you move to make them part of your record. Exhibits could be the application itself, the legal notices, any letters, that type of thing, which goes to the next topic, personal comments and speculation. So let's say that somebody sends a letter in, but they don't show up. I think I would take that in. This is Jones for sending a letter. We'll make it an exhibit. But you can't question that letter. Can you? Give it to the property, to the applicant. So I don't think you assign it a lot of weight. Petition, same way. I'm sure you've all been presented petitions before where everybody signs the petition. In my opinion, that's worth nothing. I would not rely on that one bit. Yeah, unless they're there testifying. But think about what people actually say during your hearing. Right? Now, did I just swear this person in and they told me that they were going to tell the whole truth, nothing but the truth? And then you hear them talk about crime, traffic, reduction of property values. More often than not, it's all speculation. All speculation. is there any factual basis for their statements? If I stand up there and say this, because this self-storage unit is going to move in behind the subdivision, you know how many people operate meth labs out of self-storage facilities? Can you imagine the crime? It's crazy. You need to deny this application. That's my own personal opinion. Okay, but let's say the next person gets up, but this time they hired an appraiser or a real estate agent, and they present you with an appraisal about a reduction in property value. That's some good stuff, right? I think you consider that. One of the best BZA hearings I've ever been to from an applicant's perspective, and how it was textbook, was this particular township treated distribution facilities of anything more than 50,000 square feet as a conditional use. So it had to go to BZA to be approved. FedEx came in, wanted to build a 150,000 square foot distribution facility. They had a logistics expert, they had a sound expert from MIT, a lighting expert. They had the real estate people there. They had traffic consultants. And I kid you not, the amount of documents that they submitted was this high to this table.
Wow.
Yeah. And the residents appealed. And, you know, I didn't get to use all that stuff because we got it kicked on standing. BZA granted it, residents appealed it. There were some standing issues that got kicked, but that was textbook because everybody on there said the traffic. Oh my God, the traffic. Oh my God, the traffic. And they had, I've never seen such analysis you think you've seen analysis as part of a plan development or rezoning. Jiminy Christmas. It was amazing what they did. They should, they're in logistics, but they were able to show traffic peaks and times of the season. It was amazing what they did. And that's the type of stuff that you really want to consider. So I think that's what's hard for BZA members is sometimes you gotta get it out of people a little bit. You gotta lead them down the right path sometimes. But try to get the factual evidence. And sometimes when you're doing area requirements, it's a little bit easier. That's the difference between really what you should be considering and what often is reality. It's mostly personal. Couple quick things. Legal doctrine called res judicata. So I come in, get a variance or apply for a variance from Genoa Township. BZA denies it. 3 months pass. I'm gonna file the exact same application again. Can I do that? The answer is no, unless there's a substantial change in circumstance. So let's say initially I wanted to have a structure on the property, and now I've reduced it by 25%, the structure. That probably qualifies as a substantial change in circumstance. But you can't just keep applying for the same thing over and over. That's BZA. Reconsideration. Do you guys know that you have the ability, BZA has the ability to reconsider their own decision within 30 days of rendering their decision or until the time that an applicant or property owner appeals your decision?
I do now.
Yeah. And you won't find that in the statute, but there is case law out there that says because you're a quasi-judicial body, you have the ability to reconsider. I've only seen it a few times. I would tell you, I've seen it once where the BZA completely screwed up. And it was almost like a redo to get to the right decision. Or if there's additional evidence that was not presented that could substantially change how the BZA decided, I think is appropriate. I wouldn't be doing it often. Again, I've only seen it a handful of times in my 18, 19 years. But you do have that ability. 30 days or until somebody appeals your decision, which could obviously become before that. Once 30 days passes, there's no right to appeal in this jurisdiction. Just be careful with it, but again, you can do it.
Can the applicant just ask for reconsideration without actually appealing?
Yes. So the question was, can the applicant ask for reconsideration without appealing? The answer is yes, but there better be, and typically the zoning inspector is the one that usually gets that request. There better be a reason behind it. It shouldn't be, I just didn't like the decision. But again, they can ask all they want.
Yeah.
Doesn't mean you have to give it to them. Any questions on that?
Is there, with the 30 days, is there any issue? Okay, situation, someone comes in, they want an area variance, you grant it. The person says, fine, I'm going to start working on my structure, it's now been approved. Then you appeal. What happens?
Proceed at your own risk.
Okay. So that 30-day window is a proceeded owner.
Yep. Because the next door neighbor, if he doesn't like it, it's too close to the property line, you have a right to appeal that. And the court could basically come back and say that BZA acted arbitrary and capricious in their decision.
Owner beware.
Yeah. So proceed at your own risk. I always tell people to wait till the appeal period ends before they start digging and moving dirt and stuff like that. But it's up to them. Good, that's a great question. There at the end there, 2506 is the, that's everything that I talked about, right? The reasons why a court can open up the record. So the last thing I'm really going to say is on the top of page 12. Conclusions of fact supporting the decision. So again, I think if you have a checklist with, typically when you're dealing with area variances, you're going to have those Duncan factors. You don't actually have to call them conclusions of fact, conclusions of fact and findings of law. Because what courts have said, if you don't do that, they say, well, that's really what they are, as long as you're going through them. But if you don't have conclusions of fact and findings of law, or court can infer that you've done that analysis, then they'll open the record back up. All right, so if you have a very controversial case, get a hold of Chris, make sure he's there, or one of his guys are there, and they're sitting with you, and he either is drafting your motion out, or you guys conclude your hearing, right? And let Chris write a decision for you. Then you come back and you adopt that decision. I've never lost a case where a BZA has closed the hearing and then rendered a written decision after that. Why? Because a court is going to give deference to the BZA. They have to by law. They can only overturn your decision if it was arbitrary. Okay? So again, only in those controversial cases, make sure you have somebody there with you. So that's BZA. Zoning Commission. Got it easy. Easy. Legislative. There's no requirement to swear anybody in for the Zoning Commission. And I can't point to a statute that says you have to swear people in. Okay? You may swear at them, but you don't have to. You can if you want. Doesn't hurt anything. Some people like to do it because it has that sense of formality to it. That's okay. But you're not required to. So if you don't swear people in, no big deal. Order of presentation, again, I mean, this is, typically staff report, applicant, public, rebuttal. The problem that you have to try to control when you're in the zoning commission is the Bermuda Triangle, right? Between zoning commission, public, and developer. And trying to control that dialogue so you don't have somebody in the back of the room asking the developer who's sitting at the front of the room questions and the dialogue going back and forth. You know, I like to make sure I'm keeping a running tab if I'm on the zoning commission of questions that the residents will raise during their public comment. Keep that tab and then allow the developer then to rebut, if you will, or get up and provide explanations. But try to have that communication between, two-way street and not the triangle. So zoning commission, applicant, residents, zoning commission, because it kind of gets unwieldy there when you have that triangle going. Multiple meetings, again, is something I didn't touch on with BZA, but there is a difference between a continuance and a tabling. The tabling contemplates, you're not sure when that application is going to be back in front of you. There's no time, date, place certain. If you table something, more than likely, you should be, you're going to have to re-advertise if you table it. If you continue it, you're continuing it to a time, date, place certain. And you don't have to re-advertise. So people just kind of get confused between the word tabling and continuance. And it's okay to, it's okay to table things if you don't know when it's going to be brought back up, because the developer may not know. I typically see it more at the zoning commission level, where they'll say, I don't know how long it's going to take us, but we have a lot of work to do. And we may need a couple months, so we're going to request a tabling. You have to re-advertise. But again, if you continue to time, date, place, you don't need to re-advertise.
So the 10-day or whatever would still apply. Same notification.
Appropriate considerations, and I think we may have a memo in there too that was done years ago for zoning commission to read on traffic and school. I don't know if school's in there or not.
We have a question.
Oh, yeah, sorry.
Yeah, I was just going to ask when you're talking about tabling and then there's a requirement for re-advertising, that does not then mean you have to send out notices again to the adjacent property owner.
If you're less than 10, yeah. Yeah, you got to follow the statute.
So you would have to send it out again.
Yeah.
To re-notify all the.
Yeah.
Okay. I thought that would be the case. I
Yeah.
just wanted to make
So
sure.
basically everything you did the first time, I think you have to do again.
Yeah.
And I had this situation crop up last week too, while I'm thinking about it. Condominiums, condo associations. Let's say my code says that I have to provide notification to contiguous, adjacent, across the street property. To have a condo association that abuts it. You send it to the entire condo association? Everybody in that condo association? Think about the form of ownership. Think about the form of ownership. As a condo owner, I have a legal interest. Everybody else's unit in the condominium. I've never seen a case on it, but theoretically, I have an interest.
I would ask something else about continuances. We always recommend that if there's going to be continuance, that you do it with the consent of the property owner.
Great point, Chris. Great point. So always ask the applicant if they continue, do you consent to the continuance? 99% of the time, they're going to say yes. And it waives any argument that they may bring up later. If they say no, I mean, I do have some attorneys that demand votes. And I'm happy to give it to them sometimes. I mean, but I think if you have a good reason why you want the continuance, I don't think it's fatal if you have a great reason to do it. But Chris is absolutely right. Take away the argument. Again, we talked about taking away all the hurdles and in the arguments for what.
Yeah, a lot of what we tend to run into, and this is under the considerations, before we hear stuff, most of the time it goes to regional planning. And when they do this conditional approval, that kind of contradicts or causes a lot more conflict in the meeting. How much do we pay attention to what the regional planning says versus the area people, the residents that are directly affected by it? And is there, I mean, we want to do what's right legally, but also, you know, the developer wants all those things, and sometimes we have to say no.
Hey, Scott, can you step out of the room for a minute?
Thanks, Scott.
So the question is, it's like everything, you know, what I will tell you, and not because I represent Scott or, you know, because I do some work for other regional planning commissions as well, is they're there for a reason. They're the experts, right? I'm not a land, I don't have a planning degree. So there's a reason why they're making recommendations and even conditions. But it's up to you as a zoning commission to decide whether or not you're going to follow it. I would say I would, but again, if you have a reason why, you know, you don't have to. It's not binding. But you know, that one's difficult. I mean, it's difficult to answer. But I've been able to defend a lot of rezoning actions based upon what regional planning commissions put in their recommendations, because they're the expert. It's hard to argue against them. It really is. But sometimes there's policy issues that maybe the trustees decide to make that contradict that. That happens. It's okay to deviate from it. Again, if you have a reason.
Well, and we'd love to take the feedback. If
Yes.
there's something that's particularly of issue, but, you know, we're just educated guessers, really. We're not really experts. And we know a lot of times the density number is the thing that kind of goes to the back, you know, it's the back and forth. If they're asking for more, then we don't. Yeah, it helps to get that feedback.
Communication. Yep. Communication.
One more question
Sure.
in regards to that. So when it's going through regional planning, do they reference the clump or the overlays that are in place for the area?
Yeah, we always look at that.
Okay. Even if the density that's being requested is much higher than what is in the clump? Did I just let you know what exactly I'm asking about?
Not, well, I don't know the specific case, but I mean, that happens all the time. They're always asking for more. And sometimes they have an argument that conditions have changed, just like Pete was saying, that there may have been change since the last time the comp plan was put in place. Or maybe condos do generate, you know, their argument will be condos generate less traffic than a single family house and fewer students, and so we take all that into consideration. The overlays were going to be a lot more, I mean, the overlay is the overlay, so we're kind of stuck with that.
Yes, ma'am.
If we could go back a minute on that established ground rules for the rezoning hearings.
Yes.
You have sign-in sheets. Is that hold true for regular zoning meetings or BCA meetings?
Yeah, I always like to have a sign-in sheet. I mean, I always like to have a sign-in sheet. Is there a statute that says you have to? And then going back to rezonings, when you're acting in a legislative capacity, you can put time limits on public comments. You can theoretically limit the number of people that speak. Not saying you do that. Sometimes City of Columbus, it's 3 people for, 3 people against, 3 minutes. You're the 4th person, too bad. Right? But it's because we're acting in a legislative capacity that we have a lot of flexibility. So if you have a room full of people, I definitely recommend putting a time limit on people. not maybe limiting the number of people, but definitely putting a time limit. Most people will do 5 minutes. And some people have gotten pretty creative with their little timers and everything. And I kind of enjoy it when people are right in the middle, the timer goes off. I mean, when you're sitting in rezoning hearings for like 3.5 or 4 hours, you take the pleasure in just a little things. The tedious at times. So considerations, obviously the comp plan, recommendation from Scott. You may have a thoroughfare plan. Trustees, obviously, planning commission, zoning commission, schools and traffic. I mean, schools, as much as people want to think it's an appropriate consideration, it's really not. There is some case law that tends to hint that traffic in and of itself is also not a good reason to do it, but I don't have a case law that says traffic alone is enough. It kind of trends that way. Traffic definitely is a consideration. But the question is in and of itself. I'm not sure. Again, I don't have a lawsuit that I can tell you to, but I'm sure a developer one day will, some township will say, because of traffic only, we're not doing this, and the developer's gonna sue them. But again, doesn't mean you can't address traffic situations. It's just, don't use that as your sole justification. Need for a particular use. You got enough gas stations. You don't need any more gas stations. What if, someone wants to rezone to the comp plan says general business. And I want to rezone to that, and it matches the comp plan. And you say, we don't want any more gas stations. We're going to come up with something else. You're going to use that. Need for particular use is not appropriate. Particularly when you're doing a rezoning to a standard district, not a PUD. Don't put conditions on your approval. I think you may have a tendency to run into contract zoning. I mean, you granted me my zoning. What happens if I don't do A, B, and C? What happens if I don't, that contract zoning? Standard district. Let's say you want to require the developer, we're going to grant this zoning on the condition that you install landscaping along this fringe. It's a rezoning to a standard district. We're not talking about a PUD. I grant my zoning, I get my zoning, and then I don't do the landscaping. Can I uphold that? It's not my code. No. Can't do it. No, it's contract zoning. On the standard, now, PDs are different, right? It's a whole different ballgame. But just be aware of that. So I'm going to keep hammering through. We're going to talk ethics.
Excuse me. You're saying that, let's say landscaping is a requirement for the approval, and it's agreed upon, it's voted upon, et cetera. You're saying that the zoning inspector cannot go out and find that individual for not having the appropriate landscaping?
So we're talking about in the context of the zoning commission, zoning to a standard district. So the standard district basically says that these are the rules of the game. I rezone to that. Those are my requirements. You can't add or tack things on that are extra on top of that. That's exactly what I'm saying. BZA is completely different. You can put all kinds of conditions on things.
If we have a standard, development standards in our zoning code for particular standard zoning, then we can.
You can enforce those, yeah. What I'm talking about is going above and beyond that.
So we could put landscaping requirements
in the code, and then they have to follow it. Perfect example. I have a client up in Cuyahoga, they're the only township in Cuyahoga County. They enter standard districts after you rezoned, or as part of the rezoning, they were treating it like a PD that required a final development plan. And so they had legal counsel, developer had legal counsel, took them through the process. They showed this really nice final development plan. They got rezoned to a standard district. They're like, we want to do something different. Township denied their permits. They took them to court. Court said, there's no, you can't make a final development plan as part of that process. What you're doing is a PD, and what you approved was not a PD. It was a straight district. So again, if you want it, put it in your code. You can't tack things on in addition. Again, I'm not talking about PD, I'm just talking about a standard district rezone. That's why PDs are so valuable, because it allows you that flexibility. Conflicts. Great news, welcome to township government. Bad news. You're subject to Ohio ethics laws, which could either be a misdemeanor or a felony if you screw up. But the point I want to make is having a conflict is not illegal in and of itself. Only when you act on it that there's a problem. And what it generally governs is your personal interests, those of your family, and those of your business associates. Personal interest is easy. Family, brothers, sisters, kids, spouse, parents. You're probably okay with, third cousin Eddie. LLCs, if you're part of an LLC, you're a member, or you're a sole proprietor would be a partnership. Your business associate could be an issue. Let's say Google is coming in and putting in a data facility. I have a couple of shares of Google. That's not going to be enough. I mean, you could render a decision on that. Let's say your hospital is coming in seeking rezoning, and you sit on the board of directors of the hospital. Problem. Let's say this hospital is got tens of thousands of employees, and I'm just a nurse. Probably okay. But here's the point I really want to make. We'll go in a little bit more. If you feel uncomfortable at all, call Chris. Call Chris before you do anything. Talk to him. He's going to be able to tell you, hey, I think you're fine, or we're not sure. Maybe we should get make an informal call to the Ohio Ethics Commission and get their guidance, which is a great thing. I use them all the time. But that's what you need to do. Now, even if they give you an informal opinion, the only absolute defense to an ethics violation is a formal written opinion, which they typically don't do very often, and typically takes a long time to get. So if it's a toss-up, if there's any doubt, sit it out. Took me a long time to come up with that little slip. Sit out. It's not worth it, and that's why we have alternates, right? Just sit out. Let someone else take care of it.
I've had to recuse myself in the past, so I really understand that process. So my question is kind of going to be as general as I can make it. What if my occupation makes me potentially at risk? Here's an example. I'm a lobbyist. I'm not, but you're a lobbyist for an organization who is now standing in front of the commission as an applicant.
That kind of gives me pause. Chris, I don't know how you feel about that. Because typically a lobbyist may take direction towards directly from like a board of directors.
I tend to go with here, but when in doubt, put it out.
Yeah, yeah.
Yes.
I think that, I mean, because again, a lobbyist receives directions directly from top of the food chain.
Right.
So they may have some inside information. I'd probably sit it out.
Sure.
Or call the ethics commission, run it by them.
And I appreciate that. My thought process would be as a lobbyist works on behalf of that
Yeah.
group, that applicant who would get
Correct.
benefit from it.
Yeah.
If I'm in a position to vote on something to benefit that applicant, I mean, that's a real conflict in my opinion.
Yeah.
All right, thank you.
So two primary programs, there's a link to the Ohio Ethics Commission's website is full of information. They have like fact sheets that you can read. They have all the legalese stuff on there as well. It's really good. So you can access a lot of information. Yes.
Since we're here and I have the opportunity to ask, I have a couple of family members that live in my township. If they are not adjacent properties, but nearby, what's your advice on that?
Okay, so here's the rule. So you can't use the authority or influence of your office to secure a thing of value that has a substantial and improper influence upon you as a public official. A thing of value means a definite financial benefit or detriment owed to you, your family, or your business associates. So how do you know if it's going to have a definite and direct benefit or detriment? What the ethics commissions have said is if you're contiguous, adjacent, directly across the street, you are automatically recuse yourself. Okay? Or, you know, like in your brother, sister, mom, dad, whatever. But then they say or nearby. So what the hell does nearby mean? The only ethics commission opinion that defines that term says 150 feet. So if you're within 150 feet. Now, Chris will agree, you change one fact and something could be different, like even in that 150 feet of opinion. I would then ask you, well, does the township send notice out to people outside of that? If my brother or sister received one of those notices, I would sit out. If my brother and sister are coming in to testify, I would probably sit out. Now, if your brother or sister is one of those people that show up to everything, then maybe different. It just depends, because I've had cases here in Delaware County where we've picked up the phone for a trustee who was a quarter of a mile down the road of a rezoning. It was so significant, the rezoning was, and this trustee owned a lot of property that the ethics commission just didn't feel good at them. They're like, we would probably sit this one out. So again, if you have any questions, talk to somebody about it. And if you call the prosecutor's office, talk to Chris and Mark and Vince and those guys, and if they say, well, we're not sure, maybe we should, do a run by with the ethics commission, just talk it over with them. That's fine. If they think it's okay, then go ahead. So, yeah, I think generally speaking, if they're not getting notices or not showing up, I don't think you should recuse yourself. So, but that's the rule. Contiguous, adjacent, directly across the street or nearby within 150 feet. You, family, or your business, so you gotta recuse yourself. The second major category is can't take bribes. Right, that's easy stuff. In terms of gifts that you may receive, if they're of insignificant nature, you can do it. If you meet a developer, if you're on the zoning commission, meet a developer, Starbucks, have a cup of coffee, go over a plan. That's okay. Now, If Nationwide Realty wants to take you to their suite at the Ohio State game, different answer. Different answer. So there's no, I don't know, I kind of follow kind of like the $25 rule. I mean, if it's something like below 25 and it's not happening all the time, I think you're okay. So take a cup of coffee or whatever, and, you know, I mean, sometimes I'll, drive by some of my clients, they don't have the luxury, I just live right up the street, swing by Hamburger Inn and pick up cinnamon rolls, and I'll drop them off to, zoning department every now and then, Kids like that are okay, I mean, if everybody's sharing them as well. But also make sure that your township doesn't have an ethics policy that is above and beyond state law. I don't know about anybody here in the room, but I do have clients in other counties that have stricter ethics policy.
Why is it prohibited for a trustee to attend a BZA meeting or vice versa?
So I have in here, and these aren't illegal. What I have in here is just more practical. Again, we talk about removing hurdles. So if I have a trustee who shows up to a BZA hearing and he didn't receive notice, he doesn't have standing, he comes in and complains, and based upon his testimony, the BZA denies it, and I'm the applicant's attorney, I'm going to argue undue influence.
But what if they're not there to testify? What if they're just, and vice versa? I mean, if you're.
Well, that's fine. I mean, they have every right as anybody else. It's a public meeting. They can sit there.
As long as they don't
I'd still say
testify.
that.
And again, and I'm not aware of any case law, but I've had the argument made. And again, you want to pay your attorney hours and hours arguing over a trustee who showed up, and so I wouldn't do it, but just because of that. Because I think it lends the argument that there was undue influence.
Yeah.
But having them show up and sit in the back, they can do that.
But, all right, let me address it a different way. Let's say I'm a resident of ABC subdivision, and I go to a trustees meeting and state that I am here as a resident of ABC, and I'm here to testify based on that, but they know that I'm on the zoning board or the BZA or whatever.
Yeah. No, I don't, they can do that, particularly if they identify themselves as Pete Griggs, regular citizen. I'd be a little more hesitant in terms of a rezoning process because they will have a bite at the apple. Trustee coming down to the zoning commission level and testifying, they need to wait because they're gonna get their bite at the apple. But what you described for the BZA, I can't argue with you. If I'm the property owner's attorney, I still make the argument. Undue influence. But it is what it is. I mean, I just like the separation. I mean, you guys are appointed to do a job, and I think the trustees need to let you do your job without interfering. So, I'm also been around long enough to know that's not what happens all the time. But
And the other direction, zoning.
the other direction too. So let's say the recommendation goes up and you feel that you want to go as a resident. Yeah, I can't tell you that there's anything that points to that being wrong, but you had a bite at the apple already. Why didn't you make it part of your recommendation? Right? And are you there speaking just as the individual, or, how can you separate that? I guess would be my question. Like, when you have so much knowledge in your mind, are you really speaking as a resident, or are you speaking as a member of the zoning commission? And how can you, on an application you've already heard, how can you? So I don't like it. But again, I can't say that it's illegal.
If it's a zoning issue for a subdivision and you recuse yourself because you live there, and then go to the trustee meeting, and again, address yourself only as a resident.
That's okay. Absolutely. So you don't give up all your rights, so you can still apply for variances yourself, rezonings. You can testify, I mean, you can show up to trustee meetings, general trustee meetings. Say, why aren't we fixing the roads? You know, just again, identify yourself as a regular citizen. You can testify on matters affecting you. So recuse yourself. Next door neighbor applies for a variance. You have the right to testify. Now, let's change the fact, the sister. Say I recuse myself. But now I want to show up and testify on behalf of my sister. I can't do that. That's a no-no. Yeah, that's just kind of, you know, ethics real quick. But the key is just to make sure that you're identifying when you may have a conflict. And making sure that you get a hold of somebody to walk through that process. So, yes.
I had a question about, actually, not about ethics, but about the previous section.
Sure.
Bring that up.
Far away.
Yeah, you were talking about the contract zoning. Okay, how about a situation where, a landowner has, property that's ag, wants to rezone it to FR1, okay, something like that. And, there's a structure which it does not quite meet setbacks, say, you know, it's gonna be 5 feet closer to the line, so that would be a, you know, like a variance, okay, in that consideration. And so it does not meet the code for FR1, but in exchange for that variance being granted, they would double the amount of landscaping or add a little more open space. Is that contract zoning? Or that could apply also to
Yeah, I don't know
chapter
how
15.
you agree or find somebody, find another entity.
I'm sorry?
I don't know how you, if you're on the zoning commission, how you could find another entity in terms of saying that they have to grant the variance. Let's say that you gave them the zoning. Let's say you put all that condition on there, and then let's say the BZA didn't grant.
No, it wouldn't go to the BZA. I mean, we could approve that as a variance, correct, during the zoning process. It doesn't automatically go to the BZA.
No.
It's an exception to the code.
Yeah, only the BZA has the ability to grant a variance.
Okay. All right.
So if I'm rezoning to a standard district, that's all I'm doing. You can't grant, so in the PD context, I think what we call that would be a divergence.
A divergence. Yeah,
Correct.
A divergence, I'm sorry.
You can't do that. If your code allows you to do it as part of a PD, I'm okay with that, but not on a standard district. Not if it's rural residential. You can't, the zoning commission cannot be granting variances or deviations from the code. Now, they can rezone it, and then if they have to do something that requires a variance, they would apply to the BZA. Yeah, that's how that would work.
I think you just covered there at your end statement, but just because you're rezoning something to a straight district and it happens, there's an existing structure on the property that would be rendered non-conforming, that's not a reason to A, require a variance, or B, to deny the rezoning.
Correct.
You can create legal non-conformities by rezoning something to a straight district. Just know that you may eventually have to deal with it down the road under your non-conformance standards.
Yep, absolutely right. Yep. So that's like everything I wanted to run through, which is a lot, and we're out of time. But if you have questions, I'm here. I'll be happy.